Welcome. Thank you all for joining us. I know we're starting promptly at 4. You all have things to do, so we'll get started. A little housekeeping before we start. I'm Susie Howson. I'm an advisor with the Danielson Group. Thank you so much for joining us today. This is a 1-hour webinar, and it's a one-way webinar, meaning you can see us and you can hear us, but we cannot see you or hear you. It will be recorded, so don't worry if you don't have a pen and paper and want to take some notes. You can listen back. We'll send out the link. You can share the link with your friends and family if you think they'll benefit from it. There is a question and answer panel in the bottom. If you would like to ask us a question, we may or may not have time to get to it during the webinar. If we don't, one of us at the Danielson Group will get back to you with an answer. So thank you again. I'd like to introduce Steve Ivacko of CV Trustco. CV Trustco is a boutique family office. They're a regulated trust company and they provide family office services. Steve has a very impressive resume. He's a CPA, a trust and estate practitioner. Prior to this role, he worked with one of the wealthiest families in Canada as their personal accountant and ran a multi-family office division in BC. Welcome, Steve. Thanks for joining us.
Thank you so much for having me, Susie. I really appreciate the opportunity and happy to speak to your families.
Great. So we did another webinar with Mary Hamilton of Alexander Holborn back in January, and that was a fantastic webinar. So if something comes up today that does not make sense to you, that will be explained in the other webinar. We'll send a link out with that, and you can watch it at your convenience. We don't want to repeat what Mary's done. So we're going into a bit of a deeper dive on some areas and looking at some other areas as well. So Steve, just high level, estate planning 101. Tell us what happens if you die in Canada.
Well, it depends. Hopefully you've done all your planning and had someone like Mary or yourself on your team. Yeah, ideally you've had a will put in place, and that basically gives instructions on how to administer your estate. So that allows somebody to step into your shoes. If you die what's called intestate, which means without a will, then someone, in order to deal with any assets you may have, no matter how small, if it's just a small bank account or a car, and you have nothing else, someone has to go to basically the court to ask for approval to go through that process and deal with those things for you. And so often those are things that either a close friend or if there's no family or a family member would have to deal with, and it can be a pain dealing with courts and lawyers after the fact as opposed to in advance.
Yeah, absolutely. It's just so important to have that planning in place to avoid delays. What about on the income tax front? What happens there? Do you have to pay taxes when you die?
Yeah, well, it depends on what you have. So really the only tax, well, there's two types of taxes. One, the government doesn't call a tax, which is a probate fee. And we'll get into that a little deeper in a minute. The other thing is typically on anything that any assets that you have, if there's been a capital gain, you're deemed to have sold everything when you pass away. Often though, if there is a surviving spouse, that can roll over tax-free, and then there'll be a tax on the survivor's passing. You can't have things roll over tax-free to children or anybody else, only to your spouse. The other thing, of course, is if you have a RIF account, all of that income, or an RSP or a RIF, some sort of registered plan, all of that income, all of that value gets added as income, and you get taxed on the whole thing as if you'd earned it. And so for anything over, currently $250,000, you're going to pay tax at over 50% on all of it. Mm-hmm. So
planning in place for sure. If you can minimize tax beforehand, that's preferred. So what about probate? We hear a lot about probate. Yeah. So what is it? How much is it? And why is there probate?
Yeah, so probate is basically, and as I said, it's sort of it's really a tax that isn't called a tax. And it's 1.4% of the value of the assets that are passing through your estate. So basically $14,000 per million of value. So, of your house, of your non-registered investments, vehicles, any other personal assets that you have, a boat or artwork, anything like that, everything that's listed, jewelry is a big one as well, often. And so, yeah, anything that has to, in a company. So anything that has to be listed on your probate document as something that has to pass through your will, it gets added to it. So yeah, that's
This is paid to the BC government, and that for them to administer the estate.
Correct. So that basically, it gives you then the court, then once they receive the check and everything's sort of approved, they stamp it, and that is basically, the government saying, the court saying, this is the absolute will, the last will of the person, and anybody can rely on it. And so usually it's really required, honestly, for just land title transfers and for financial institutions. So, and depending, sometimes ICBC, they can be a little bit flexible on that, but things like corporate shares, artwork, personal things, they don't need probate in order to pass on to somebody else in order to give it to a beneficiary. But if you have to go through the probate process, you have to include everything. You can't sort of pick and choose unless you do a dual will structure, which I think Mary may have gone into, but we won't go into that today. But
yeah. So really, I mean, there are ways to avoid probate, and as advisors, we often make recommendations to avoid probate where we can and where it makes sense. But I know that there's a lot of situations where it does not make sense and it's not good. I'm sure you have some stories. Can you share a few stories with us and explain maybe when it doesn't make sense to avoid probate and just pay the 1.4%?
Yeah, so often the biggest one, or there's two, and there was a court case recently that a couple of them recently, where someone had, for example, to avoid probate, to make estate administration easier, had put their home into joint names with their child. Then, unfortunately, that child got into some financial trouble, some legal trouble, and was sued. That the person, the entity suing them, saw that he was on title on this home and basically put a lien against the house, even though that was never the intention. So basically, this parent who thought they were being simple and trying to make things easy for themselves and for their family, actually made things a lot more complicated for themselves. The other thing too, where a lot of people have just basically put everything into joint accounts or in registered accounts or segregated accounts, and this actually happened to us where someone had named us in their will to be the executor of the will, but we almost ended up with zero cash in the estate to be able to administer it. So the estate wouldn't have been, there were assets there, but in order, for the 4 or 5 months leading up to the ability to sell the house, we almost had zero money in order to pay the bills. So the fact is that the estate was too efficient, which can also, hamstring whoever your executor is.
Mm-hmm. And I imagine when there's multiple kids and one child gets added on, they get that asset potentially when the parent dies, and then the other kids are left without the asset, right? So there can be a lot of complicated factors there.
Well, and that's happened before, but recently a lot of court cases have said unless someone has specifically gifted that item to the person, it's then falls into what's called a resulting trust. So basically saying that even though it's for estate planning and it can skip probate sometimes and blah, blah, they're actually just holding it in trust for the estate. So if it is actually a true and honest gift, then you actually need to paper that. So we had a situation recently where, 90-year-old woman had her daughter taking care of her son, somewhat more financially independent, and the woman wanted the daughter to have the condo for taking care of her for, she didn't have a job for years because she spent so much time taking care of her mother. And so we went to and it's actually a client in common with Mary, is, they said that, change the title, put it in joint ownership, said the beneficial ownership stays with mom until, she passes away, and then it'll transfer as a gift to the daughter outside of the estate. So it didn't have probate, had got the principal residence exemption, and that sort of thing. That's another actually issue with putting a home in joint names, is potential loss of the principal residence exemption or portion of it. So you really need to be careful with that, and make sure you get a lawyer and draw it up properly if that's the actual intent.
I think that's the important thing to note, is just getting proper advice, because things do change. There's court cases and things, they change all the time. That leads us to sort of beneficial ownership versus legal ownership. Often people can get confused about that. I'll give you an example. We have a lot of clients with non-registered accounts. So we add on the spouse as a joint owner, but beneficially the first spouse is the one that's taxed on the income. And it's just if they pass away, will directly flow to the survivor. So can you explain beneficial and legal ownership in that regard?
Yeah, well, and similar to a home, it's what's on title. It's what, and part of another piece of tax interference in this is what's called attribution. So where did that money come from? So that's why you have one spouse being taxed on it, even though it's in a joint account, because the funds probably originally came from the initial spouse. So that's where, again, you'd want to paper that, if it's other than a spouse. So for example, if you're putting a child on as a joint owner, again, you want to paper that to say, is this a gift or isn't it a gift in the end? But yeah, so basically, even though someone else's name may be on it, one person is the beneficial owner, means they get to enjoy the rights and titles and all of it, and any income or to the capital of it during their lifetime. And typically the other person wouldn't have any interest during someone's lifetime, and again, unless you sort of paper that properly. Yeah.
So in BC, wills variation claims are a really important thing, and everybody should know about it because everyone who has a will. What is a wills variation claim, and why is it so important for us living in BC?
Yeah, well, BC is one of the most liberal provinces in the country for sure, and basically allows anybody who could have an interest, so typically a spouse or a child, if they don't feel that they've been treated properly or adequately enough in a will, they can challenge it. Regardless of what someone may say or what they may have been told during their lifetime or anything else, someone can say, look, I deserve more. And we've actually got, and so by doing some planning in advance, you can sometimes avoid those types of issues. We're going through one of those right now where one child was named over the other ones, both financially favored over their siblings, as well as was the sole executor. The two siblings said, this isn't right. We deserve to all be treated equally. And now they're suing each other, and we are the court-appointed administrator of this estate. And between the lawyers and us, and the estate value is just getting dwindled because dad didn't want to spend the 5 or 10 or whatever $1,000 to hire someone like Mary to do the paperwork properly in order to avoid a lot of this.
Absolutely. So, and minimum, what do you think typically when you see these wills variation claims on a fairly large estate? What's kind of the minimum cost it's going to be for all the lawyers and for everyone to get involved?
Yeah, all in, it'll probably cost the estate at least $250,000. So 250,000 just to, you got lawyers on both sides. If you've got somebody else who's acting as the executor, they're going to have, their own counsel as the executor as well, even if it's, the same person. It might be a beneficiary acting as an executor. So, it easily, between, unless you're going to, mediate fairly quickly and everyone's going to, play nice in the sandbox and decide, okay, we don't want all this trouble, you're looking at a lot of money to deal with an estate where there's people have dug their heels in.
Well, for sure, when you start getting families involved and emotions, that's when people just kind of look away and just spend the money. They don't even see it all going. So it's really good. It's really important to plan, especially I guess in situations when you think about it, second marriages, if there is a black sheep in the family, potentially unknown kids that you don't even know about that could step forward, right? Especially nowadays with all this DNA testing. So it's really, I'm sure there's a lot of good stories there, but it's important to have a plan in place. So like what kinds of things can you do? And I guess that brings us to potentially alter ego, joint partner trust. Do you want to speak a little bit on those? I know Mary did speak on them already.
Yeah, so basically there's a specific part of the Tax Act that allows you to set up a separate entity effectively where you can put your assets that they'll pass outside of your estate. So if something isn't going through your will, someone can't challenge it under the Wills, Estate and Succession Act, can't challenge to vary it. They can try, but there's actually been some court cases recently, and obviously Mary can speak to this a lot better than I can, but they they've been proven to be an effective planning tool. And so that's basically taking the assets out of your own personal name, out of your estate, giving them to this other entity, this trust, and that trust then is the one that administers the estate. So in those cases where and it may be for very good reason, where someone wants to treat their children differently, or, as you said, there's a black sheep, or, someone's, just separated, and they haven't, been in touch with each other for 10, 15, 20 years or whatever it is, or they just don't want to give their kids all that money or too much money. Sometimes that, that's the case as well, or they just think, okay, well, I just want to help them a little bit, or not at all, or I've given them enough during my lifetime. I want everything to go to charity. And if that's something that, some people want to do, give everything to charity, and it's just in your will, your kids can challenge that. And they're going to be, if it's one of the larger charities, like one of the cancer ones, or, the universities or the hospitals or things like that, they've got deep pockets, and they've got lawyers that unfortunately, do this kind of work, and they can challenge that and say, well, this is what the person wanted. And so again, it can get messy.
Absolutely. So with the alter ego joint partner trust, you have to be 65 to set up, and we have a lot of clients that want to set them up and have questions about them. Yeah. So it does add a complicating factor. I mean, there are benefits. You avoid probate. There's privacy, because a will is not private. So if you want to be private, and it avoids a will variation claim. So there are very specific reasons why it would be very good to set one up. But some clients just, if it's just probate and there's other things they can do, they have questions about the logistics, the accounting. So we don't often get into that. Can you tell us a little bit about, like, how do you pay bills? Who pays the bills? What if you want to make a donation? Just a little more on the administrative side of having one of these trusts.
Yeah, so basically what you would do is, when the trust gets set up, you gift whatever, assets you have into it. So maybe your principal residence goes into the trust. So title has to change. Maybe your investment accounts, your non-registered investment accounts go into the trust. So that's paperwork with you and your team to be able to change those assets into the name of the trust. And practically speaking, then you also absolutely should open a bank account in the name of the trust, so that when there's money being withdrawn from from their account here with the Danielson team, that they those funds go into a bank account in the name of the trust. And then for your family's, your clients' day-to-day expenses, they would write themselves a check out of the trust into their own personal account, and then pay all their bills. There is actually a box you can tick on the tax return where you can pay bills directly, as long as it is, again, for the benefit of a beneficiary. So for an alter ego or joint partner, it can only be the person who settled it. So the person who's over 65, the family. You can't use it to pay bills for your kids. You can't use it to pay for other sort of just fun things, or like that. It really, you want to be as clean as possible on the accounting, and not risk Revenue Canada saying, well, this isn't really an alter ego trust, and it's an inter vivos trust, which is taxed completely differently, and again at the marginal rates and all that stuff. So, and it can create a bit of a mess. So it's just a little bit of bookkeeping, making sure you dot the I's and cross the T's. Now, from a donation perspective, during your lifetime, again, the only people that can benefit from it are the people that set it up. So mom, dad, whatever, just the 65 plus client. If you want to make a donation, again, you just write yourself a check out of the trust, and then make the donation personally. So on passing, that can be treated in a different way, but during your lifetime, that's sort of the way it has to happen. Otherwise, you risk tainting the trust for tax purposes, and you don't want that.
So just to clarify, you can still give your kids gifts. You can do that. You can make donations. You can pay Absolutely. For things. CRA is not going to tell you how you can spend your money, but it's writing that check from the joint partner trust directly to them that could be a problem. It's writing it from the trust, to you, and then from there you can do whatever you want with it, right? It's Correct. Not handcuffing you how you spend your money.
That's right. Once it's out of the trust, you can do whatever. It's yours. You can do whatever you want, like you would have done before. But in the meantime, you have that protection of the trust itself, for all the reasons we talked about already.
Okay, great. So again, with respect to donations, because you want to get the tax treatment, the tax credit for them, how does the tax work then? So, you're paying out yourself some money and you're making the donation personally. Then how does that all work? Can you explain the tax returns and what filings are required?
Yeah, so for an alter ego trust or a joint spousal trust or partner trust, you have to pay yourself all of the income out of the trust. So basically, the trust will have zero income and zero tax, and all of it goes into the hands of the settlers. So the people who set up the trust. So for example, if they've got an account here and you maybe got 5 or 10 slips, T3s, T5s, whatever it is for the investment income, personally before, all of those are actually going to go into the trust now. So the trust is going to get 10 or whatever slips, T3s, T5s, and then when whoever's doing your, putting the tax returns together is just going to issue one slip from the trust to you personally for all of the income, for all the investments, or if you have, real estate rentals or anything like that in there, same thing. All of the income will go to you, and then you've personally made a donation. You personally get the tax receipt, and so again, it all sort of happens on your own personal tax return. But you have to have that flow through process in order for it to work properly.
Okay, so it definitely is additional administration and additional cost for filings, and obviously to set up, but it definitely makes sense in a lot of situations, and it's got to be client specific.
Yep.
Great. Anything else? I was just thinking with a joint partner trust, something we run into, like if you defer your property taxes, if it's owned by a trust, you cannot defer your property taxes. Right. So just something to note. Yeah. May not be the end of the world, but
and same with the grants as well. Depending on the value of your home, you can't apply for the grant anymore to get a reduction in your property taxes. But I think the threshold's $1.5 or $2 million value. I can't remember off the top of my head, but it's in that sort of neighborhood, I think, where you don't get a grant if the value is over that anyway. So it could be moot for people. But yeah, for some the deferral is great because it's basically a 1% loan from the government. So you lose that, the opportunity cost there, but you're still, again, benefiting from the bigger picture things. And again, if there is a risk, because of family issues, we actually set one up for my mom when we lost my dad. So that was going to be, from a value perspective, there isn't much there, but because of a potential family risk, there was, we decided to do it anyway, for sanity and and harmonious reasons.
Yeah, and also, just things that we talked about, the principal residence with properties, it is a little tougher because you have to pay property transfer tax. It's really like a sale from their point of view. Yeah. So you do have to be careful there. Maybe you don't want to put your principal residence right away. Maybe if you're going to sell it and downsize, you would just continue to own that personally and then buy the new one in the joint partner trust.
That's right. Yeah, and you can always contribute more to it later. So that's a great example of selling your home, downsizing. You can then, put all the funds into the trust when you sell it, and then the trust can buy the next home. Absolutely. That's a great way to do that.
Good. Awesome. So yeah, if anyone has any questions on those, please don't hesitate to ask. I did get one question here. Is there a minimum value of assets that would make one of these a viable solution? Sort of if it makes sense, if the trust is worth a certain amount.
Again, it really depends on the family. For family harmony and avoiding of future hassles and potential lawsuits, even under $1 million may be worth it to spend, the $10,000 or whatever, 15 it's going to cost to set it up, if it's going to avoid, stress and strife and fights down the road. To me, that's worth it in this particular case. But again, everyone's going to have their own cost benefit analysis.
Mm-hmm. And it's really what's important to that family. If it's avoiding probate, there may be some other way to do that. Or if it's privacy, or if someone bringing a claim to the will. That's
right. And by cost benefit, I don't mean just financial. I also mean the emotional and, the personal toll that going through all those things can have on a family.
Mm-hmm. I know. I've seen several stories. I'm sure you've seen many stories where after the fact, it just things just crumble, and it's not nice to see that.
No, not at all.
Switching gears to executors. So everyone, in your will, this is often, we stumble on executors and guardians. Who should be your executor? So people want to name a friend or a family member, and no one's really sure of who to name. what are your ideas on naming, you know, kids, one kid, multiple kids, if you have multiple friends?
It can really be a challenge sometimes. So one thing for certain is if you're going to name somebody who is your contemporary in terms of age, make sure you have an alternate in there. So you don't want to just say it's going to be my spouse or it's going to be my sibling or something like that. If you're close in age, you know, and especially if it's a spouse, for example, if one passes away, the other one may not have capacity when the first one passes away to be able to change their own will, for example. So you may be stuck there. Things change, people move, people marry Americans, they move to the States. If you're naming your child, that creates a whole other set of problems when all of a sudden you have a non-resident, for tax purposes, that's your executor. If you name a child and they, leave the country or even leave the province, that's a problem. Well, and geography, again, here people often move to BC because they want to retire. Their families on the other side of the country or other side of the planet. Again, that just adds a whole level of complexity. So finding, somebody local, somebody ideally much younger, or at least that doesn't have any, health issues, but of course life happens. Often if someone's got multiple children, we've seen cases where, there's one sort of more capable child, whether they're a professional of some sort or whatever, if they're an accountant or they're a lawyer, that's fine, but that doesn't mean that they can be good at this job. And it really is a job. For several months after someone passes away, it is a job. So if someone has a full-time job, if they've got kids, they need to get to sports practice or dance recitals or whatever. And now they're, emotionally challenged, obviously, by losing a loved one, a parent, somebody close to them, or a friend, and then have to do their regular daily routine ongoing. That is an extraordinary amount of stress and extraordinary amount of, it's a burden, frankly, if it's not something you do every day. And even if you are, if someone's an accountant, maybe they work in mining or something, or if they're a lawyer, maybe they work in, some other industry of, aerospace or something. Just because they can do that doesn't mean they can do estate law or estate accounting or estate, or administering an estate, because that's a whole other set of legislation, of laws, and there's a lot of overlapping laws. So as you said earlier, you've got WESA, the Wills, Estate Succession Act, you've got the Tax Act, you've got provincial rules in terms of actually administering an estate. So there's a lot of different layers of different laws, different rules that apply to being an executor. And in a case where, for example, let's say you want to pick all your children, that again can be a challenge. If you've got, we're dealing with an estate now where there's 4 executors, 4 co-executors, and it is difficult because it's like herding cats. It's really challenging, especially when not everyone's on the same page. You had one child, or 2 children in this case, that were professionals, and they're sort of the favorites, the golden children, as the, some of the other siblings put it. One of them is a bit of a black sheep, but, really is assertive personality. And yeah, after all this, I don't know that they're ever going to have a holiday dinner again together as a family, because it is, the second parent to go. And, there's a lot of, just a lot of complexity. So that can often be, a real wake-up call to, who you're working with, because you're effectively putting your family and business together if that's what you're doing. It's a short-term business, but you're putting them in business together, and that may not be a good idea.
What are some of the duties that an executor has to take care of? I'm sure there's, administrative, but there's also things like on the ground that you've got to take care of. Can you name a few things that you have to take care of?
Absolutely. Well, the immediate thing, of course, is dealing with, with the deceased in terms of remains. Hopefully they've left instructions, or, whether they're formal in the will or, somewhat detailed, at least with somebody who's close. Ideally, it's in writing. Because otherwise then you could have multiple people competing for saying, they said this, or I heard this, or, whatever it can be. And then, once that's settled, then you get, and even before that gets settled, you've got business to take care of. You've got banks to notify, you've got Assante to notify, you've got the Revenue Canada, make sure, if they're getting some sort of a pension from somewhere, there's a laundry list of things. If utilities are in their name, a big one actually, and this came up in a situation where husband and wife, they were married for 50 years. Husband was an executive, wife typical stay-at-home mom, great job, wonderful family, everything. When dad died, everything was in his name. So her credit cards got canceled immediately because they were all in his name, and she just had a subsidiary card as opposed to having her own card. So, if you're going to the bank and you want to make sure that, you don't lose your ability to put gas in your car, that's something that you want to, deal with fairly quickly. And the challenge too, especially with financial institutions, and nothing personal here, but they have a lot of rules to follow. They get a lot of, people at tellers often just have never dealt with things like this before. They don't know what's going on. They've got to find a manager. They don't do this every day. And so they don't know the rules. They don't know how things should work. And, again, often when somebody goes in and it's obviously a very emotional time and it's stressful and everything else, that can just add another level of stress. So, just even small things like that. Then it's, filling in paperwork for both the investments, for the home, for the government, Revenue Canada, and ultimately, collecting all the assets, making sure that you've got everything. Some creditors may come out of the woodwork to say, this person owed me money. You've got to verify all of those sorts of things. If there are unique assets, we've dealt with, where people have either a car collection or some sort of jewelry, or, we worked in an estate one time, there was a 500 bottle scotch collection. So how does a family deal with that? They don't know what to do. And, you've got the liquor regulator all of a sudden. You can't just go out and sell that. A lot of people collect wine and things like that. There's a lot of different things, a lot of different hats you have to put on. And then if you're one family member of a large family, you're also, referee, you're gatekeeper here. You're, trying to manage expectations of everybody. You've got to deal with all those things. And then ultimately you're dealing with Revenue Canada. And what people don't often realize, so number one, for probate, once you get probate, you actually technically aren't supposed to distribute any assets out of the estate for 210 days, unless just for the risk of some creditors coming out of somewhere, or the estate end up owing Revenue Canada money. So if you over distribute assets, then the executor is liable for that. So in a case of a single child being a beneficiary of a family, something happens, they're probably going to write the check themselves, and because it's all their money anyway, in that particular case. But if there's anyone else involved, if there's a charity, there's nieces or nephews, there's somebody else, anybody or multiple children, you don't want to be distributing anything early. And then again, you really should get what's called a tax clearance certificate. So that means you file a tax return, you get a notice of assessment, and then you have to file for what's called clearance. And that basically is the fast forward process that Revenue Canada uses to say, okay, we review the history here. There doesn't look like there's any mistakes. Everything's fine. You're all clear and free to go. And then you can fully distribute the estate. But most people don't even realize they need to do that. Mm-hmm. So again, it's a whole other job with a lot of technical things and nuances that most people don't even think of.
Not to mention clearing out somebody's home and all their belongings and what to do with all their stuff.
Exactly. That's exactly right. And finding,
do you do that for clients or?
Yeah, well, yeah, we coordinate that, absolutely. And we have a team of people that takes care of all those little things. And often we'll, when we work with families in advance and talk to them, we'll say, well, if there's specific things you want to go to specific people or places, you can do that. Just write it. You don't have to put that in your will. You can do that in a separate, send me an email and tell me what you want done where. And we'll, as long as it's practical and possible, we'll do that. We'll make it happen. But again, if we don't know, and maybe there's some valuable piece of art that you've been hiding in a drawer somewhere, or jewelry, or a family heirloom, something that is super important, historical family item that other people may not know about, and somebody may, some great nephew somewhere may want, great aunts, some sort of, watch or whatever it is, or a piece of art, you want to make sure that you put that stuff down in writing.
And one thing that I think you told me is basically if I have a will and I appoint someone as executor, if they pass away while they're in my executor, I inherit their executor. So that's not ideal.
No, and often that can happen if there isn't. And again, it depends on how, you know, the will is written, and if there are any alternates, or if there, you know, again, there's a lot of legal nuance here. But that, and again, we were on a file where that actually happened, where there was, you know, 3 siblings. One of them passed away. The brother was his executor, and then the brother lost capacity, and he didn't have, you know, an alternate. His executor was the brother who had passed away. So, and they were actually both suing their sister, which was a whole other issue. And so we had to step in and try to clean this up. And it was, yeah, you know, we ended up getting appointed by the court on that because that person didn't have capacity and there was no other option. So the lawyers on all 3 sides actually had to, you know, sort of get everyone's approval and go and, you know, move forward with that.
So let's just say that I'm appointed as executor of someone's estate, and I don't want to act, or I don't know what to do. What can I do?
Well, 2 options. You can actually say no and walk away, and you know that's happened. You know, if there is someone, you know, behind you as an alternate, you know, that may, you know, well then they're up to bat and see if that's something that they can or want to do. We're actually we're acting as agent for an executor on a file where they're still the executor, but we're doing the work and they're paying us to do that. It was a woman who passed away, no kids, husband predeceased. She had 4 alternates of friends and coworkers that she'd picked, and everybody said no.
Unusual.
Everybody said no until the last person, and then the last person said, well, I'm going to get paid, and don't blame her. And you know, typically if you don't specify in a will how much your executor gets paid, they can ask for up to 5% of the assets, of the value of the assets, as a sort of a lump fee when everything is sort of said and done. And so this person had basically said, you know what, if you want me to do this, because I'm the last option you have, I want 5%, but I'm still going to hire somebody and the estate's going to pay for them to do the work. And I get the 5% for the legal liability. So, and yeah, and that's ongoing. So, you know, either specifying in the will how much somebody can get paid, you know, if it's an hourly rate, if it's a professional, you would typically put, you know, if it's an accountant or a lawyer or whatever, they're going to get paid their hourly rate. If it's, you know, a person, a family member, you may want to specify, you know, what that number is going to be. Maybe you fix it at 100 or 150 or $200 an hour or something like that for them to do that work. That said, if they're going to get paid, the estate now has to apply for a payroll number, has to withhold payroll taxes, so CPP and EI on that, and just like it's a regular job. So that's, again, another thing a lot of people don't understand, which again, then people don't typically put that in their will and say, well, my child's going to do this for free, they're getting the inheritance anyway, all of that. But if there's multiple children and one of them's doing all this hard work, they should absolutely ask for money at the end when they're going through all the formalities, ask for a percentage. Maybe it's not 5, maybe it's 2 or 3 or something, but they should definitely, you know, seek remuneration. But then you could have the other sibling saying, well, why are you asking for money to do this? And this is a family thing. But if they're the ones actually doing it, had to take time off work, had to, you know, miss recitals or miss sports things for their kids because they had to deal with, you know, dealing with mom and dad's estate, they should absolutely get paid.
I think people don't realize sometimes how much work it is. So you, in the absence, if you don't say there's any fee in the will, that person can charge up to 5% of the value of the estate.
They can, yeah. So I mean, it still has to go through the court and get approved, but they can ask for it, absolutely.
Okay, and I guess, like you said, you have to apply for payroll, so that means it's taxable to the executor. Correct. But you actually don't get the corresponding tax deduction in the estate. So it's not very efficient from a tax point of view, except for the government.
Basically.
Yeah. So what are some other ways then that you can specify a fee for the executor in your will?
Yeah, well, either, you know, you say, you know, if it is a professional doing it, this is, you know, they can bill their rates, whatever they happen to be. If it is, you know, just pick an hourly rate for somebody, if it is a family member or not. I mean, even if you say, if they act as an executor, then their gift or something, they get an extra gift portion. But if they have to do the work in order to get that, then it's a fee in which they're going to have to pay tax on. Or yeah, just agree to something in advance. So what trust companies, professional trust companies always do is negotiate a fee agreement in advance. And so right off the bat what you're going to pay, what at least what the percentages are that you're going to pay, and then whatever the value of the estate is, when the time comes, that's what it's going to be.
Can you give a range of your fees of how much, just a range?
Well, and all the companies are different. You look at the banks and they'll typically start at 4% for the first million, 3% for the next million, and sort of a sliding scale like that. For us, we just basically have a bifurcated, 2% on the first 5 million of assets, 1% on anything over. But when we start getting, north of 10 million, 15 million, then we'll negotiate a specified fee that makes sense for everybody involved.
And somebody can either, so just to clarify, in the will, they can appoint a professional executor, and that could be CV Trustco, so they would not have a family or friend being the executor, or they could have a clause in there that or they could be agent for executor. What is agent for executor, and how does that differ?
Yeah, well, so that would be, let's say, you were named executor for somebody, and maybe there was no alternate, so you felt an obligation. They were someone you loved very much, and you cared for them. You wanted to do right by them, but you don't know what you're doing, or you don't have the time to do it. So you can hire a professional firm to do that work for you. You're still legally responsible for it. You're still signing everything. You're still, signing the tax return and the applications for CPP, and signing whatever investment document paperwork needs doing. But the firm that you hire as the agent is, it will do all the grunt work basically for that, and they can empty the house and do all those sorts of things, and you can do sort of as much or as little as you want. And typically for that, we would just charge by the hour, and for who's doing the work and what their skill set is, or what's required. So with that family I mentioned that where the 4 siblings are co-executors together, they did a bunch of the work. They cleaned out the house because 2 of them are retired anyway, and but a lot of the more heavier lifting stuff, coordinating the tax things, coordinating the government, coordinating the financial institutions, all that stuff we did for them.
I can imagine in a situation where there's 3 kids and 1 child gets appointed, and if people are upset, they want to charge for their work, and they may not realize how much it entails. If they hired an agent and paid a third party, that might be more harmonious for the family.
Absolutely. Yeah.
Can you talk a little bit about, so you did say with executors, they're liable for tax. And so if you make a distribution and then there's tax owing down the road, the executor is the person who has to actually come up with the money, or they have to go back to the beneficiaries. Correct. Is there any other liability they have to worry about when you say payroll or GST or anything, or all those things come up?
Absolutely, all of those things. So anything, well, any creditor basically that has a right claim, whether it's the government or other, if you've over distributed and the beneficiary has already, they may have spent the money already, who knows, it's up to you as the executor, so you're on the hook for it if you've done things sort of not by the book. So I mean, if somebody comes down the road and it's past the the deadlines and all that, and they say, oh, by the way, this person owed me money, but in that respect it's too late from the statutory and the legal timelines, then yeah, there isn't necessarily a risk there, but something can always get challenged if you did something wrong, or I don't want to say if you did something wrong, but if you didn't do everything perfectly, someone can really make life difficult for you. And again, you have to, if there aren't any more funds in the estate, then in order to defend yourself against any lawsuit or anything like that, you're going to have to pay out of your own pocket, because if the estate doesn't have any more money, then again, you're in trouble. You're out of pocket for that stuff.
So you're saying if I'm an executor, I get appointed as executor, and I don't know what I'm doing, and the beneficiaries are asking me for money, and the charities, so I'm just writing checks to everybody. Then it comes down, there's actually a creditor, maybe not CRA, someone else.
Yep.
They can come after me and my house and my assets.
Well, and again, that would have to go through the courts, but yeah, you're effectively liable for it, basically.
So you really are accepting quite a lot when you accept the role.
Exactly. So yeah, it's often not for the faint of heart. And again, you know, some people can probably do it technically, but again, when you throw the emotions, you throw the family dynamics in there, you know, whether there's you know, spendthrift children or others, and you know, you get the demanding, and that's the other thing too, is where, you know, you've got one sibling or, you know, family member in charge of somebody else's inheritance. You know, someone could be very demanding. Someone could be, you know, a lot of people just don't understand, and they can say, you know, where's my money? Where's my money? Calling you every day, where's my money? And you may just get fed up and write them a check and say, get away from me, enough already. And then, you know, that's a mistake that could really cost you down the road. So yeah, there's a lot of things that can go wrong.
Estates can take a lot of time. Is that right? I'm sure what's the longest time you've seen the estate?
Well, there's a couple that we're working on. We're almost at about 2 years now for a few of them, and you know, depending again, and unfortunately, one of the quirks to this whole thing is when you die, because that's also depending on tax returns and things like that, and you know, seasonality of a lot of professionals, and what happens in the legal world, and how, you know, in the courts, how busy they are, all those things, you know, that are completely out of your control. Well, and you know, for people that passed away just before COVID, when we were doing, you know, their returns and the government shut down and you couldn't, you know, get things signed and all that, you know, there was a few estates that got held up because of that. And, you know, it was just, you know, you're waiting for your tax assessment in order to be able to make sure that it's all fine and good. And, you know, we were waiting months for some of them, which normally would take, you know, 4 to 6 weeks. So yeah, there are a few, you know, estates can, and depends on the complexity. If there's real estate of some sort, if it's rental properties or commercial or industrial real estate or things like that, or unique investments, for example, if there's, you know, things that are illiquid, some sort of, you know, excuse me, hedge funds or alternative investments, you know, that are hard to value or you know, hard to change the ownership of, those things as well, or, you know, have specific hold periods on them or associated with them. Those can drag things out. So yeah, there's a lot of complications. Excuse me, and that can.
So we talk about leaving a legacy, and obviously we all think we're going to be around tomorrow and to clean this up, to do this, and to have our wills in place. Do you have some stories about where things have just been left a mess and it's caused, you know, some difficult times for the family after?
Yeah, unfortunately, the biggest one that comes to mind, and it's really frustrating for me, because it was someone who was, you know, was a friend of the firm, knew us, you know, was a professional. It seems like didn't have a will, because they went to the doctor, you know, weren't feeling well. The doctor sent them basically directly to the hospital. They did a will on, you know, in the hospital, and 2 weeks later they were gone. They had passed away, and they made the spouse the executor. Now the challenge there is that, again, you know, professional, you know, sort of the typical story. Once they got married, had kids, the spouse didn't work anymore, stayed at home. You know, usual, you know, wonderful travel, wonderful lifestyle, you know, house by the ocean, all that sort of stuff. You know, sort of downsized, retired, penthouse now, all that. And as it turned out, the husband actually had, you know, a bit of a mess left behind that, you know, he had always anticipated. You know, he didn't anticipate getting cancer and getting sick and all that stuff. And, you know, I'll clean it up one day and I'll deal with it. There were years of unfiled tax returns. The condo in Whistler turned out was in a corporation when the wife specifically didn't want that. There was all sorts of, you know, things, and the challenge for me was basically for the first, you know, so she hired us to be agent. For the first 2 years, every time she came into my office, she was in tears. Ended up writing checks, you know, for about $250,000, $300,000 to Revenue Canada for interest and penalties and back taxes and things like that. And they had this wonderful marriage of 30 plus years, and this wonderful family. And his legacy, in my mind, I think, just based on conversation subsequently, is completely tarnished. And so all of the first 30 years of wonderful have been marred now by this last 2 or 3 years of just mess. And it's unfortunate. It really is. So sort of putting those sorts of decisions off, putting those just procrastinating, putting everything off to another day, you're just leaving that for whoever's left behind to clean up after you. And it's really not fair to have somebody else have to clean up your mess.
While grieving, obviously, then making
while
it
grieving, absolutely.
extra hard. Yeah.
Exactly.
So just shifting gears, do you have some sort of hot tips for will planning? Just a few things that you can kind of impart with us and that we can incorporate into our own planning?
Yeah, I think, being clear about what your intentions are, or at least if you're going to be vague about things, leave instructions to whoever your executor is going to be on those specific things. So, doing a letter of wishes, for example, which is not legally binding, but it can offer direction. And those are things that you can change on a regular basis. Revisit your will every 4 to 5 years, absolutely. And, something may not change, but legislation changes often, the rules, tax rules, everything else, those things change. So, and, if there's a life event, absolutely change, go to your lawyer, get it updated. The other big thing too, and I can't stress this enough, it's sort of the professional, yes, a lawyer can be expensive sometimes, but you're getting what you pay for. Because if you go to somebody who, maybe they do real estate conveyancing, or they do corporate stuff, or they're sort of a sole practitioner, they may know a little bit, but if you have a little bit of complexity, they may know a little bit about a lot of things. But if there's some complexity to your estate plan, that's sort of like taking your Mercedes to a Toyota mechanic. I mean, they may be a lawyer, maybe an accountant, whatever, but if they don't do this and live this stuff every day, they don't necessarily know all the nuance or all the the pitfalls that can happen. It's a transaction, and your life is not a transaction, and your legacy is not a transaction. So that's one thing I would stress, is spend the extra few dollars, go see somebody like Mary Hamilton, who does this for a living, does it day in and day out. Her and her team, and there's a ton of people out there that are just specialists in this.
And also, like, just picking your executor, I guess you should tell them that they're your executor, make
absolutely.
sure they're willing to act. And what is the concern if you pick an executor and you think, oh, you're going to anything, you're going to change your will, but let's just say I lose capacity, what's going to happen there?
Yeah, well, and again, if you have somebody, we've had a few cases now recently where someone has called and said, I need to redo my will. The person I picked as my executor has passed away, and I need somebody. So they're ultimately going to hire us just because of who else they have or don't have in their world. And that's a great example. If you lose capacity and something happens and there's no alternative, again, it's sort of, an interested party has to go apply to the court. So if you have a will, if you've lost capacity, you can't change your will if you don't have capacity. But then again, whoever's maybe predeceased or isn't an appropriate choice anymore or whatever, that can again put a big crimp in the plan. And so and not having an alternate.
So what would happen though? Let's just give an example. I lose capacity. I have adult children, and one moves to the U.S. So now I can't change my will. What would happen in that case? Am I stuck?
Basically, yeah. And then on your passing, so ideally, during your lifetime, they can still do what they need. Hopefully, you had a power of attorney and a representation agreement to deal with your healthcare issues for the representation agreement, power of attorney to deal with your financial affairs. But yeah, if something's happened with whoever you've named as your executor isn't the appropriate choice anymore, but you've lost capacity, you can't change your will. Now, if your power of attorney has the ability to do planning for you, there are, and again, you need a professional like a Mary Hamilton to do that, where, sometimes it can allow for moving into an alter ego trust or things like that during the lifetime. But again, those are, really complex bits that you need to talk to, talk to someone like Mary about. And as long as all the beneficiaries are the same, that can be done. But again, there's a lot of nuance there as well.
Basically, it's complicated. Get appropriate advice.
Yeah. Sorry, it's sort of an accountant or a lawyer answer. Yeah.
No, that's the way it is. Yeah.
It depends.
Okay. So closing off here, we're just coming up to time. Can you just tell us a bit more? We've heard about what CV Trustco does, what you do there, but I know you have different divisions. Can you tell us a little bit about your firm?
Yeah. So we were founded by and owned by a bunch of accountants and a lawyer. So we've had our own careers. One of the challenges with a lot of the bank trust companies, for example, is that if someone who started as a teller and just worked their way up and decided they wanted to do or if they thought trust would be fun or something or interesting, there are good people there, of course, but as an organization, there's a lot less flexibility. So for us, we've each built, ran, and sold businesses for ourselves or for other people, and this is realizing that people who have some complexity, and often people say, well, I don't need a professional, my world's not complicated. Well, you're the one that built your world. For you, it's not complicated. But for anybody left behind, looking at it, trying to piece it all together and stepping into your shoes, it's complicated. So, having the ability to do that and to have done that for, a decade and, longer in other roles, to be able to step in and when there is some complexity, where there is tax problems, where there are jurisdictional issues, often blended families, those are really always complex, regardless of the number of zeros behind someone's name. So those are the things that we thrive on and that we really, like to do. The other piece, of course, is that, we do, if all we did was, act as executors and trustees, then, I don't necessarily like the expression, but we're just waiting for people to die, which isn't really a good business plan. So we do, tax planning, estate planning, philanthropic advisory, so similar to a lot of the additional things that you offer your families, Susie, with that. So, and the other thing is, of course, we don't replace anyone's advisor unless there's an absolutely good reason to do it, but not, we're not going to upset the apple cart just because we can. And working as a team and, playing in the sandbox with everybody, working with you, working with the lawyers, working with the accountants, working with everybody who's already there is key to our ability to do our job properly. Because if we just did it in isolation, then, it's no different than a layperson doing it. And you've already built your trusted team around you of your advisors. Why would we throw all that, that history, that knowledge of you as a person and a family? There's no point in throwing that out the window. That would be silly. So we don't do that. We step in where we need to, we augment what's already there, and, let all the professionals that know what they're doing do their work and basically just coordinate them in the end.
So you've scared me today. So I'm going to run home and let's just say I want to update my will and change maybe I'll have an agent for executor, or if I decide the professional executor, what do I do? How do I go about appointing you?
Yeah, so basically what we would just do is, you go to your lawyer. We have specific language that we would include, sort of a paragraph to say, I'm going to name CV Trustco as my executor. There's a separate paragraph to say, and we would negotiate a fee agreement in advance, what the costs are going to be. Then there's a paragraph that says this fee agreement, CV Trustco gets paid this, and it's basically added as an appendix. As far as the agent piece goes, you can't legally put that in there. You can say that there's a preference to use that if you want, whoever your actual executor is going to be to use someone. You can, much like an investment advisor, you can't specify that because then you're taking away the ability, the discretion that the executor needs to have in order to be able to do their job. But you can say, if in this situation, this is my preference. So you can add that line in there, for example, for the agent piece. And it's up to the executor to do that. But otherwise, yeah, for us to be able to do that, and again, often we're alternate for, so often where a spouse will be the executor for each other, we're the alternate to the second one, but on the passing of the first, so that we can help the surviving spouse and do all the actual work for them, for example, where a couple does it that way, or yeah, we're often and we've seen this a few times where someone has had a will. A child doesn't want to say no to a parent. They don't want to offend them. They don't want to, hurt their feelings while they're alive and to their face. But say, what, if something happens to me as child, to mom and dad, let's at least put a plan B in place, an alternate to me in case something happens to me or in case my life turns upside down or whatever it is. And then, ideally when the time does come, that child can say, okay, well, I don't want to do this. I'm out of here. And here's the alternate plan. So that's also an option for people out there to do that and just sort of have us as a backup plan.
Okay, and let's just say I get appointed as executor and I'm overwhelmed and it's just too much, I'm too busy. Do I just pick up the phone and call you, or what do I do?
Absolutely. Yeah. So in either way, if you're, if we're an alternate executor, or you just want to hire us as agent, just pick up the phone. If you are going to step back and renounce as an executor, you really have to do that fairly quickly, because if you put yourself forward as the executor, that you're going to, like even in the first week, other than dealing with the remains, typically with any service or anything like that, but going to the bank, going to the government, going to the investment advisors, things like that. As soon as you put yourself forward as the executor, you're the executor. So the process to change that is very difficult. So that's where either, okay, you can do that and then call us to help you through the whole process, or if you just want to wash your hands of it, you got to do it as quickly as possible.
Good point. Thank you. Well, we've come up to the hour here. It's come up quick. So thank you so much, Steve, for imparting all your experience with us and your knowledge. We appreciate it. We appreciate your time. And we thank you all for sticking with us. If you have any questions, please don't hesitate to let us know. Just reach out to your advisor. Any one of us can answer them. And again, this will be recorded and we'll send out a link. So thank you and have a great evening.
Thanks, Susie. Thank you, everybody.